Good evening and welcome to this session of the live learning classes conducted by the Board of Studies of Institute of Chartered Accountants of India. Let me just get the query pad on because it's already there. I'm just going through it. And sorry, somebody is asking for important questions. I didn't say that. Today's class, I don't think I can give important questions. Sorry. In fact, in this live learning classes, Mr. Karthik, I do not give such questions and all. I don't think I ever promised. I might have mentioned that when I was conducting physical classes, I give questions. I might have mentioned that I do that. In these live coaching classes, live learning classes, no questions will be given. I thank you that you are looking forward, but no, I can't. Who am I to give important questions in the ICAI Board of Studies? No way. Please. So you put it in Tamil and all, but 100% I'm not going to give you anything. Never have I ever given in these classes. Check out. In the earlier any batch I have given. Okay. Such things I used to do once upon a time when I was taking physical classes, not today. Please understand, Mr. Karthik. Don't mistake me also. Okay. But of course, I appreciate that you all consider this to be the last class, and I'm very happy that I could be of service to you. See, there are if you want important questions, it is there in the cracker. There is a book published by Taxman called Cracker. Just go and take that cracker. All the questions are there. So thanks for informing that FEMA slide is not updated. It will be done. Along with interpretation, I will upload FEMA also. Okay. It so happens I uploaded General Classes Act, but FEMA has not been uploaded. I will upload it. Don't do. Okay. Thank you. And Anish Kumar is asking a question whether 387 will apply to a foreign company issuing shares in India to its existing, which are of different class. It will see once they have a establishment in India, automatically 387 will apply. Okay. Once they have any place of business in India, automatically it will apply to them. That is the answer. Okay. I will just one more thing. I'm not able to offhand answer your question, Manishji, because I don't have the sections with me. I may have to check up. What I will do is you raise this question as part of the queries to the ICAI. You raise this question to the ICAI. They will send it to me. I will answer it to you. Okay. So today I can't answer. It's a really interesting question. I will also take it and keep it. You raise it. You send it by mail to the ICAI query pad. Then they will send it to me. You tell them to send it to me, then send it to me. Then I will definitely give a reply, which they will send it back here. Okay. Offhand, I'm unable to answer your query because today I have to take this topic, which is so today we are going to get into interpretation of statutes. So let us also have somebody was asking for an invocation as the last class. Definitely. Sahana bhavatu, sahanau bhunaktu, saha viryam karvavahai, tejasvinavaditamastu, ma vidvishavahai. Okay. So with this, let us begin the topic for the day, which is interpretation of statutes. So basically, this topic consists of interpretation of statutes, deeds, and documents. Okay. So we have certain terms which you need to understand quickly. Then rules of interpretation are very, very important. And the primary rules are very important. Then maybe some of the secondary rules. Then the aids are there, internal aids and external aids. Finally, how to interpret deeds and documents as against statutes. See, statutes are there. There are statutes, and we have deeds and documents also. Okay. So how to interpret deeds and documents? Now, already we know that statute means the laws and regulations. Any act of parliament, any act passed by parliament is a statute. Okay, the written will of the legislature. Okay, so an act enacted by the legislative authority, central government, Parliament of India. State governments have the legislative assemblies. So any act passed by the legislative assemblies or by the parliament is a statute. Okay. So whenever we say statute, we always talk about a written law, which would be available in written form, as against custom and usage, which is unwritten law. In a democratic, okay, rather in a parliamentary democracy like India, in a parliamentary democracy where we have a parliament, anything to be applicable to me should be a law passed by the parliament of my country. You cannot simply say, this is what we will do, this is our law. No. If you want me to follow it, you should show that it is there in the act enacted in parliament. If such a law is not there, no. Of course, in addition to that, certain laws will give power to the ministries, the executive, to give rules. So these rules could be made and those rules could make it applicable to me. Then a rule should have the permission of a law and that rule gives me. So that rule also become my statute. Are you able to understand? Law passed in parliament is a statute, but that law says central government has the power to make rules. We have seen so many rules now. So those rules which are made by the executive, but as empowered by the statute, are also statute. So at a different level. In addition to that, there may be some doubt as to what is meant by something. Then there will be clarifications by way of circulars and notifications. Circulars and notifications. That is not statute. That is not statute. That is a circular or notification given by the government. The government is giving it as a clarification. I can't do further interpretation of a clarification. That is the end of it. I can agree with the clarification or I can say I don't agree. There are many circulars given by CBDT to which many of us don't agree. So we go on appeal. For example, Section 14A of the Income Tax Act. There are many circulars that have come from CBDT which we don't agree. And we go on appeal against that to Supreme Court. That is where the judiciary happens. Where I don't agree with what the executive says as to what the law is, I can go on appeal against that to the judiciary. So the judiciary consists of various levels, right from the appellate authorities within the framework of the law. Like in FEMA, we have the appellate commissioners. In income tax, we have the commissioners of income tax appeal, like that. Then the tribunals, then the quasi-judicial bodies. Then above the tribunals, you have the high courts. Or in some cases, like against the National Company Law Appellate Tribunal or the Competition Commission, you go directly to the Supreme Court. So this is the hierarchy of appellate. So that also gives some law, but that is not statute. That is not even unwritten law. It is called judge-made law or precedent. Precedent. I don't know where this is. Precedent. Okay. Precedent. Okay. This topic may get you 4 to 6 marks. 4 to 6 weeks. One question, sure. 4 marks to 6 weeks. Okay. So this is regarding statute. So the word statute is parliament law. Any rule made based on the sections of the act. So that is why many times we say section so-and-so read with rule so-and-so. So the section tells what is to be done. The rule says how it's to be done. Together they are statute and they can be interpreted and they are applicable. They are bound. Citizen is bound. Beyond that, any clarifications, notifications and all. See, notifications are different. Everything is made public by a notification in the official gazette. Everything is made public by a notification. This topic is a little complicated topic. I cannot make it simpler than this. So you will have to raise yourself a little, one step above where you are and understand me. Okay. This is the best I can do to simplify it. Topic is not this is not a 5th standard or 6th standard topic or even college topic. This is the higher level topic. Okay. So by now you are aware of the law. So you have to little bit increase your knowledge. So all we are doing here is we are trying to understand what is statute. Aisha Patka, you know that there is a parliament now. You know that the parliament will make law now. That is statute. You know that when the law is made, one ministry will become responsible for the administration now. Like Ministry of Capital Affairs, Ministry of Home Ministry, Home Affairs, right? Finance Ministry. That ministry is called executive. The law, which is the statute made by the parliament, give power to the executive to make rules. Central government make rules. Those rules are also statute because they are made by permission. That is all. If you are still not understood what are you going to do, you tell me. Okay. Now, Manohar Yadav is asking a nice question. What is the difference between rules and regulations? Beautifully asked. See, in FEMA, Foreign Exchange Management Act, you have rule and you have regulation. Rules are made by central government. Regulations are made by RBI. SEBI also, you have rules and regulations. SEBI, the rules are made by central government under the SEBI Act. The regulations are made by the Securities and Exchange Board of India. You have various regulations. Sometimes they are also called code, takeover code like that, but basically regulations. So when a quasi-judicial body makes certain type of code of how to do procedure, that will be regulation. Whereas when central government itself, based on the permission given in the act, does it, it is called rule. In FEMA, you can see there are two different sections. One, empowering central government to make rules, which is why your current account transaction rules made by central government, prohibiting certain transactions, etc. Whereas thereafter you will find everything is regulation, FDA regulation. Then you have capital account transaction regulations. So these are all regulations made by Reserve Bank of India. Okay. So this is how it is. Okay. So similarly, we have document. Now, you have already seen the General Classes Act document. Okay. Similarly, under the Indian Evidence Act, you have document. Any matter expressed or described upon any substance, okay, by means of letters, figures, or marks, or by more than one of those means. See, you know, both these laws, the Indian Evidence Act 1872 and the General Classes Act 1897, were drafted by Lord Macaulay. Genius. According to me, genius. Okay. In fact, he wrote very simple laws. So here again, he uses, in General Classes Act also, he says, any matter written, expressed, no, sorry, 1897 is not Macaulay. 1872 is Macaulay. 1897 is not Macaulay, sorry. But 1872 read, any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means. Here they say, they are following Macaulay. Any matter written, expressed, or described upon any substance by means of letters, figures, or marks, or by more than one of those means. Okay? And the purpose of such a mark is to record. So very, very fundamental definition. They are not using the words, okay, paper or parchment or vellum. No. They are using the words substance. The word substance is very wide. It includes this membrane on which, you know, this my screen is being displayed, the display. Okay, on which, you know, what you are now reading is being displayed. Your screen on which it is being displayed. There is also a substance. And the institute rather is describing by means of marks, letters, figures, or marks, certain things. And the purpose of it is to record. Very wide definition. Going beyond 1872. Since sitting in 1872, Macaulay could not have imagined digitalization of this world. But he knew that if he used paper, he would have restricted his definition. Therefore, he said substance. It could be anything, wood, rock, anything. So I think that is where Macaulay has to be appreciated. That he used substance for making, not only did he say letters, figures or marks. Think about it. Okay. So very wide definition, very interesting definition also. See, some of you, if you are only thinking by knowing all this, will I get mark in the exam? Maybe not. Out of this, only some portion will come in the exam as a question. But if you are able to listen and appreciate what I'm saying, no, your maturity level as a future member of our institute will be better. So sometimes, in life, I'm also told, please reply shortly by Krunal Singad and all. Sometimes, you have to be long. To understand certain things, you have to be long only. If everything I can shorten it now, then some meaning will be lost. So in the exam also, you are in a hurry to give an answer, you write something short, you won't get full marks. Sometimes you have to be a little long. You should know what is comprehensive, you have to write. So don't be in a hurry. People who are in a hurry, generally they make mistakes. People who are calm, they generally get things correct. I've noticed that students who are in a hurry, go. In the exam, they go and they're in a hurry. They make mistakes. Costly mistakes. So don't do that. All is well. Our answer. In common parlance, instrument means a formal legal document which creates or confirms a right or records a fact. Example, lease agreement is an instrument. It creates mutual rights and obligations between tenant and landlord. Lease agreement. Your articleship, once you enter articleship after finishing intermediate, you will enter into an apprenticeship agreement with your principal. It is an instrument which creates rights and duties and rights. You have certain duties, he has certain duties. You have certain rights, he has certain rights. When all this is put in the form of a document on stamp paper, it becomes a legal document which creates. So such thing called instrument. Instrument is a wide term. Even an affidavit is an instrument. Affidavit is nothing but a record of facts, a statement of facts on a stamp paper with a verification or with a oath you saw in general class. So it is a formal statement which records fact. Okay, it's an instrument. So it is a formal writing of any kind, such as an agreement. Even an affidavit is an instrument. But an affidavit is not an agreement. Agreement is different. Agreement is between two parties. Okay. Again, Indian Stamp Act instrument includes every document by which any right or liability is or purports to be created, transferred, extended, extinguished, or recorded. Okay. So right or liability. Like that, anything is put in writing and meant to bind us legally, formally legal. And that is why Indian Stamp Act says, what is the stamp to be affixed? Now, you may not want to know this because it may not be relevant for the exam, but from the exam point of view, this may not be relevant. But what will happen if an agreement is not stamped? Suppose a lease agreement is not stamped. Can it not be produced in a court of law? It can be produced in a court of law as a supporting evidence, but it will not be conclusive evidence. Meaning, the tenant or the landlord cannot say, I am a tenant based only on that document. That will be one of the documents he will produce. He has to produce so many evidences. Since it is not stamped, it will lose its evidence as a primary evidence. It will be only corroborative evidence. But suppose it is stamped with the appropriate stamp, then the court will take it as prima facie evidence of the tenancy. Evidentiary value will be lost if you don't stamp it. Even if you don't stamp it, it can be produced as an evidence in a court, but its value will go down. The other evidence will have to be proved, etc. Whereas if you have a stamped, properly stamped, signed, evidence, witnessed, possibly notarized document, the other party cannot deny. See, the other party cannot deny. Okay, because it is a clear cut. The court will say, look at this agreement. Now, on this agreement, you talk. Don't waste time like that. So, deed by which ownership is transferred. Legal disposition, big English term, many of you may not understand. Don't worry. Any document by which ownership is transferred is deed or title is transferred. But sometimes, the entire ownership may not be transferred. Limited title can be transferred. For example, when I create a mortgage on the property, there is a limited title. The lender gets a limited title on the property. So that is also deed, mortgage deed. Suppose I'm giving a lease of my property for more than 12 months and above. Then there is a limited interest in my immovable property to the tenant. So deed, lease deed. If it is 11 months, it is lease agreement. Stamping is different. Lease deed has to be stamped at the value, the future rental value, 4% you have to pay. Whereas agreement only 100 rupees. Okay, in Tamil Nadu. Each state will have its own rate. Okay, so deeds are also instruments because some rights are also created, liabilities are created, but all instruments may not be deeds. Okay, no. So this is some preliminary. When we use the words, deeds, documents, what is it? Now we come to the words interpretation and construction. Yeah. Whenever I'm putting bold, it means in the exam, if you are at least write the words which are given in bold. Now, these two terms are used interchangeably. It is not as if they are two different terms, but slight distinction can be made. Okay. Construction and interpretation. Okay. When you are talking about interpretation, there is an ambiguity in the law. The ambiguity means the words of the law. From now on, I will not use the word statute. I will use the word law. But when I use the word law, please understand, I'm meaning statute. Because you don't like some complicated words, I will use simple word, law. Basically, law is statute. So the words of the law or enactment, the enactment because it is an act of parliament. The words of the enactment, if they are clear and unambiguous, ambiguous means capable of two meanings. Ambiguous means capable of two meanings. Where they are clear and unambiguous, they need not be interpreted, they should be obeyed. But suppose there is an ambiguity, there is a possibility for two different meanings, then it is the duty of the court to give an interpretation and say, this is what we think is correct. Okay? That the court can do. Also, we can do. As professionals, we will say, this ambiguity, I'm interpreting it this way, like that. Whereas finally, the High Court and the Supreme Court will decide what it is. Okay. Now, suppose there is an ambiguity, we are unable to resolve it. If I give effect to that words, it will lead to some sort of an absurdity. Then I have to look at why that law was passed. What is the reason for that law? And try to find out which interpretation will help to achieve the goal of the law. See, every law is passed with a goal. We have an end in mind. That end is mentioned in the beginning of some enactments as preamble. Your FEMA also has a preamble. Consumer Protection Act has a preamble. Many laws, Constitution has a preamble. The preamble states the purpose of the law. So, where there is an ambiguity and it is so difficult to resolve, then you can look at the purpose of the enactment as stated in the preamble or as stated by the minister while introducing the law in parliament, whatever, and then say, hey, if this is the purpose, this is how it has to be understood. That is called construction. Whereas when I'm resolving the ambiguity by deciding, hey, this is what it means, then it is called interpretation. There's a small distinction, but you can. So there are two types of interpretation, legal and doctrinal. Okay. Doctrinal. When there is an actual rule of law which binds the judge to place a certain interpretation of the statute, then it is authentic. The legislator himself has told. In many cases, the explanations will be there to the section where they will say, for the purpose of this section, resident means, so that you don't have to have doubt about what is resident. I have told you. Authentic. The law itself is telling. Or it comes from some other source such as custom or case law. Say a word is not defined. It is not defined in that law. It is not defined in any other law. Nor is it defined in the see, we can take a dictionary meaning. But in some contexts, some meanings are custom, followed by custom. You can use that. That is called usual interpretation. Doctrinal, when its purpose is to discover real and true meaning of the statute. That's what I told, na? That is construction. Basically, where you're trying to find out the real and true meaning, that is called construction. So, you try to find out what is the purpose of the enactment. Okay? Of course, you have to use the rules or words used in the enactment, but if they are ambiguous, confusing, then you can go out. Now, this is a quotation from Lord Denning, a famous jurist. I have not taken the entire quotation. It is there in your material. I have not taken it, but only this part. Okay. I know, I don't know, when I'm teaching this topic, I'm a little worried because many of you may not understand much of what it says here. But if only you can understand English and appreciate what Denning has said, now it will be really great. I'm telling you. Just like, sometimes I read Ghalib, Mirza Ghalib. I don't know Urdu. I feel bad. When I'm reading an English translation, I feel bad. Then I try to read transliteration in Urdu and try my best to appreciate from the way, from the Urdu point of view, because I don't know Urdu, but I try to learn. Why? Because only then I can appreciate the beauty of Ghalib's poems. Okay, like that, if only you knew good English, now you will understand this. The great language that this great judge is using. See, he says the English language is not an instrument of mathematical precision. See, it is not algebra, where, there can be only one way of understanding one answer. I'll tell you, even in mathematics, deductive logic, there is only one answer. Inductive logic, there can be many, many options. And as you get into complex mathematics and probabilities, there is no one thing. Even there is no mathematical precision. But by and large, mathematics is precise. 2 plus 2 is 4. Okay? Rules are it's very clearly stated, right? So, whereas the English language is not an instrument of mathematical precision. There are definitely confusions. Our literature would be much the poorer if it were. Okay? Anyway, don't leave that line. You will never understand it. This is where the draftsmen of Acts of Parliament have often been unfairly criticized. All that Denning says is, yes, when somebody is trying to write something in English or in, not even English, any language, he may make mistakes. When such mistakes are made in the law, a judge should not sit quiet and do nothing. You should not blame the draftsman. He says the judge should roll up his sleeves and do something about it and interpret and resolve the ambiguity. So Denning says the judge should, that he should. What does he say? He says it is the duty of the judge, okay, to interpret it. In the absence of it, when a defect appears, a judge cannot simply fold his hands and blame the draftsman. He must set to work on the constructive task of finding the intention of Parliament. And he must do this not only from the language of the statute, but from the social conditions which gave rise to it, and the mischief it was passed to remedy. So what Denning is saying is, where there is an ambiguity in the law, a judge can go beyond the words of the statute, look at the social conditions, look at why the law was passed and what was sought to be done. And then he must supplement the written word so as to give force and life to the intention of the legislature. So this is something that I used to enjoy. Lord Denning was a famous judge, and jurisprudence is the study of justice, law. That is not just law, but the study of how justice is done. Okay, you can say that is a study of the roots of law. What is just? What is justice? What should be done? What should not be done by a judge? That is jurisprudence. Okay, it's a very, very important topic, but not for you. That's meant for lawyers only. Jurisprudence. There is how should a judge approach a matter, and what are the fundamental rights of a citizen? What are the natural rights which everybody has, and all that. Okay, these are contained in jurisprudence. Constitutional law, where the Constitution gives you certain rights and liberties. How far are these rights available to you? How much can the Supreme Court help you? What is the power of the Parliament itself to make a law? That is jurisprudence. Does Parliament have the power to make this law? Like that. Okay. Prescience means divine prescience. Read the word together. Divine. Prescience means knowledge. Prescience means knowledge. Knowledge. Not just ordinary knowledge. Divine prescience. That is, God knows what happened, what is happening, and what will happen. Right? So divine prescience is when the parliamentarians are able to think like God and know what is going to happen. So they don't have divine prescience and perfect clarity. So they may make mistakes. Okay, is the point. So so Denning says, whenever there is an ambiguity, a judge can go for interpretation. If so, then what are the rules available to him? There are many rules of interpretation. You have rule of literal construction, reasonable construction, harmonious construction, beneficial construction, exceptional construction, and then we have a rule called rule of ejusdem generis. Then you have certain secondary rules also, okay, which means contemporaneous justitia, and nocitor associate. We'll see that. First, a literal construction. Okay, this is also known as a cardinal rule. First of all, they say where the words of a statute are clear and unambiguous, there is no need for interpretation. For a clear proposition needs no expositor. From now on, you will be seeing a lot of Latin terms. If you can remember them, remember. If you cannot, if you think this topic is a little above your head, 4 to 6 marks you will lose. So leave it. But if you think you can remember and enjoy this topic, you are getting 4 to 6 marks sure. If you read this topic well, 4 to 6 marks sure. Okay. So there a little bit, if you can remember the Latin maxims, it will be good. See, absoluta sententia expositor non indicate. That is absoluta sententia means clear proposition needs no expositor. When plain words are used, capable of only one interpretation, no explanation is required. See, so no explanation is required, right? This is the basic rule. It's called rule of literal construction. When the words are clear and unambiguous, even if they will cause hardship, you have to give the literal meaning. Literal means as it is said. Do what I say literally means do what I say as if what I have said. Okay. Sometimes when you take a person literally, it may lead to, for example, when somebody enters my cabin, I will say, sir, please take your seat. Please take your seat. Doesn't mean he has to lift the chair and keep it somewhere or take it. Then suppose somebody is asking, sir, I have taken the seat. What should I do? No. What I mean is, take your seat means, please sit down. So if somebody who has knowledge of idiomatic English will understand. But somebody else who doesn't know that way of, formal English may say, what is saying, take my seat like that. So sometimes see, that's what I'm saying, English like that. But where the words are clear, they should be given the full meaning, right? In fact, once when I was conducting a one-day workshop for a group of engineers, finance or non-finance, I used to keep on saying, I will explain a concept like, say, break-even chart. And then I'll say, I hope you get where I'm coming from. I hope you get where I'm coming from, like that. See, that's an American idiom. So I hope you get where I'm coming from. Means, do you understand? I hope you are understanding what I'm saying. I hope you get I hope you get where I'm coming from. Where I'm coming from means the meaning that I'm giving. Whatever. So, since most of them were IT engineers, most of them understood what I was saying. But a couple of these people who come from certain remote parts, no, they didn't understand what I was saying. But anyway, later on, at the end of the session, I asked any questions you can ask me like that, 20, 30 minutes. So everybody was asking doubts on discounting, what is this, what is that. In reply, Then finally, one of the students stood up and said, Sir, from morning you are telling, do you get where I'm coming from? Do you get where I'm coming from? But you are not telling where you are coming from, sir, like that. So it means he thought I'm mentioning my native place, where I'm coming from. So this is the problem. Clear proposition means anything which is stated. Proposition means anything which is stated. Clear proposition means what is stated has no ambiguity. There is no doubt about what I am saying. In that case, it should be clear. It should be taken. Okay. If you don't like the word proposition, substitute the words. A clear statement needs no explanation. Shall we put it that way? If I use the word statement, if you are comfortable, use it. Because most authorities use the word exposition, a proposition. But if you think proposition is a little too unnecessary, you can say a clear statement needs no further explanation. That's all. What is clear? Sometimes. Words used in the popular sense, well, in dealing with the matter, the general public, statutes are presumed to use words in their popular sense. But sometimes they are technical words also. In which case, the laws should define. Okay, that is why General Classes Act is there, defining words. In case the law is not defining, you can go there. In case both are not there, you can go to dictionary. Many times, CIT appeals, income tax, in CIT appeals and tribunal, I have won cases by using dictionary meaning. I said, look here, the act doesn't define. Okay, there are other laws that are defining. If you want, you can take that. Or let's look at the normal dictionary meaning of what this is. And this is what happened. Okay. Sometimes, I'm sorry to say, the income tax officers also don't know English. Okay. So generally the phrases of the statute ought to be given their literal meaning. Literal means as it is stated. But when the grammatical or literal construction leads to a manifest absurdity, then the courts shall interpret the statute. Interpret means give meaning so as to resolve the inconsistency and make the enactment a consistent whole. Make it a complete. So where there is ambiguity, that's how we have to do it. You should not reduce it to a futility. Means you should not make it absurd. Okay. My guru, Professor K. Santraman, who is a great teacher of interpret, this topic he used to teach. I learned how to teach this from him. He used to even warn me when the Companies Act 2013, before that, there was a 2099 ordinance which became 2000 amendment. Full of, 2009 ordinance which became 2010 amendment. Full of ambiguity. Myself and Professor K. Santraman reading every new section, amended section, so many errors. So he used to call me and say, Srikanth, what do you think? So I'll give him my view. Then he will say, no, don't give like that. You should not reduce it to a futility. You should give life and soul to the enactment. Sir, I'm saying, sir, where is the life and soul? Sir, they have killed it like that. But still he will try to interpret it. Now we used to have fun interpreting something which is not interpretable. Okay. leading to manifest absurdity only it used to have. That is where they go for harmonious construction. Where there is possibility of, where they go for reasonable construction. They say where there is an ambiguity, then you give a reasonable construction. Okay. While doing that, you have to look at the purpose of the enactment. So reducing to futility or means making it absolutely vague and meaningless. No, you should give meaningful interpretation. Okay. So that is up to the court to do it. Again, we lament with Denning that it is better if the acts of parliament are drafted with divine prescience. We only wish those who draft these laws would think and draft. So there was one section 185, there is rather in Companies Act, which you will read when you come to final in self-paced mode. Now that law is tamed, now that section is tamed. In the early stages, that section was an unruly section, confusing section, creating so much hardship. Then after much representation, the Ministry of Corporate Affairs, they amended it. And the section that you now have is a good section. You should have seen it in 2014. Where there are in an enactment 2 or more provisions which cannot be reconciled with each other. They should be interpreted wherever possible to give effect to both of them. That is called harmonious construction. Harmony means both should be aligned to each other. Okay. The opposite of harmony is conflict. When there is 2 people are fighting with each other, they are in conflict. Harmony means when their conflict is resolved and they are made harmonious. Conflict means 2 people are fighting with each other, conflict. When somebody goes there and says, hey, what's your problem, man? No, he says that. No, boss. In these situations, you are right. In this situation alone, he is right. So that is a harmonious construction. So they say, okay, you are clear now? In all these things, I am right. Only here you are right. These are called where you are trying to resolve the conflict. You should interpret the statute in such a way as to harmonize it. Make it aligned. One easy way is to say there is a specific rule and a general rule. This is an easy way of resolving conflict. Where it is not possible to give effect to both, then collision can be avoided. Conflict can be avoided by holding that one section merely provides for an exception or a specific rule different from the general rule contained in the other. A specific rule, see, in those days in the old law, there were some good examples. But here, I can only give you a specific rule will override a general rule. That is why in some cases they will say, whenever they make a specific rule, they will say, without prejudice to the generality of section 49. So general 40, whatever, that section will give general rule. They say without prejudice. Then what they will do, they'll prescribe a specific condition where that section won't apply and this section will. So a specific rule becomes an exception. The general rule will apply in all cases other than this. So a specific rule will always override a general rule. So generalia specialibus non derogant. Where there is a specific provision, it cannot take away from the generous, or the general provision cannot take away from a special provision. A specific provision. So how do I know if it is a specific provision? If it is applicable to a specific situation. If that situation is there, then the general provision will not apply, only the specific provision will apply. So this is how we resolve the conflict. Okay? And we say, there is a general provision, this is a specific provision. Specific provision will prevail here because it applies to this. The rule of harmonious construction is applicable only where there is a real and not merely apparent conflict. See, in many cases, the act itself will very clearly clarify who is superior, who is not. See, there are many sections where they themselves will say, notwithstanding the any section, this will apply. That means automatically this is a specific provision, notwithstanding. So whatever may be said in other enactments, in this situation, this is prevailing. Okay. So these are, when we come to those notwithstanding, and I'll explain to you. We move on to Hayden's rule, or rule of beneficial construction, also known as Hayden's rule. Friends, I am teaching it like this, but it is not so. Beneficial construction is different. Hayden's rule is different. Okay. But unfortunately, somewhere our institute has combined the two. So whenever in the exam they ask you beneficial construction, you have to write this only. Okay. Though there is another beneficial construction rule. Anyway, basically it is like this. There is something wrong in the society or in something which has to be corrected. For that, the parliament makes a law. That law also has a has an ambiguity. Now, what to do? They pass another law, correct it. That also has a problem. So then only the rule of Hayden's rule will start applying. Okay. Where it is clear and unambiguous, you can't use Hayden's rule. But where the language is capable of more than one interpretation, then you can apply the rule in Hayden's case. Okay. It's a very old case. Can you see? 1584. 1584. This was decided when there was no just the Parliament of England has come during the reign of King John, and they're just coming, and the Parliament itself doesn't know what its powers are. It's trying to come. Okay. At that time, the barons of the realm, they were hearing a case, and they said, there is a law which was prevailing before. Then there was a mischief. It was corrected. But in spite of that, there is an ambiguity. Now they will say, what is the remedy? What was it that the act wanted to do? Let us give effect to that, the reason for the remedy. Let us give effect. Let us ignore what is there in this law and give effect to the remedy. So in a way, when we apply Hayden's rule, we are totally doing away with rule of literal construction. Rule of literal construction says, where the provisions of the act are clear and unambiguous, literal, do what it says. Here they say, but then once you say there is an ambiguity, then only you start all these things. So here they say there is an ambiguity. Then find out what is the mischief being perpetrated. Find out what was the defect for which the law did not provide. Now correct it. That's all they are saying. And interpret it. Now, the rule of exceptional construction stands for the elimination of statutes and words in a statute which defeat the real objective of the statute or make no sense. You can say, hey, this word does not add any value. We will ignore it like that. See, you and I cannot do this. Only court can do it. Now, there was a question asked by Manish Kumar. He says or and. It's a very interpretative question. That is, he's saying 2 subsection matters to be have or, well, subsection 4 of subsection and. There is a difference between or and. That much I can tell you. Whenever the word or is used, okay, you have an option of doing either of this. But when and is used, both have to be completed. In your definition of small company, the word and is used. That means both the conditions have to be satisfied. Both the conditions have to be satisfied. Okay. But for certain other sections, you will find the word or is used, which means even if one condition is satisfied, the section will apply. So usually they will give or when they want to make the law applicable to you. So that even if one condition is satisfied, the law will apply. When they want to give exception, they will put and. You have to comply with both. Only then you will get the exception. Professor C. R. Bhupati, our past president of our institute, while teaching in Income tax used to mention this. Whenever they want to give you a benefit, they will put R. I'm sorry, they will put and. So you have to comply with all the provisions. Then only you'll get the benefit. Whenever they want to do something bad to you, they'll put R. Even if one of the conditions is satisfied, you're out. Okay, that's the point. So in this case, but then where there is no such intention, then you can use both R and for R. That's also there. There's no big difference. But where it will make a big difference in compliance, then and is always conjunctive, bringing together. Or is always distinctive, separating. So or will separate and say either this or that. So even if you get one, you are out. Whereas and is conjunctive, bringing together. If you don't combine, if you don't apply, both are not applicable, not applicable. So you are saying that the word and is used, then it is conjunctive. That means that both have to be complete. So it is assumed that when the word and is used by the law, it is used, it's used consciously. And the intention is that both conditions are to be satisfied, or both documents are to be filed, or both have to be there. Okay. And one more thing, 387.4 and 26.2 are not parallel sections. They merely talk about the same subject. So they are not parallel. Okay. 26.2 will apply to that situation. That's what 387.4 says. So in addition to that is 387.4. Okay. There is no conflict between the two sections. If that's what you are asking, there is no conflict. Okay. Both are applicable. That is the point. Already we have seen may and shall many times. May is directory. Shall is mandatory. When a provision uses the word may, you have an option. See, suppose I say you may come in, you have an option not to come in also. But you say you shall come in, you have no option, you have to come in. You shall do it. Then when it says may do it, then there's an option. So may normally indicates a power, which has an option. Whereas shall generally indicates a duty. Rarely do they use the words may and shall independently. There is whenever shall is used, shall will always be a mandatory. No option. You have to do it. May, there is an option. But there is one situation where, in my humble view, they use the word may, but it has the meaning of shall. That is, when there is a rectification of name, they say a company may change its name by passing an. They say a company may change, the company shall change its name by passing an order resolution. There I feel, though they use the word shall, it becomes may only. Why? Because they are saying you shall change your name. How? By passing an order resolution. Now, I go to my members and ask them to pass. They don't pass. What do I do? I mean, you can ask the directors to do something, we'll do it. But you ask me to pass an order resolution, that is not in my hands, I say. I call for a meeting, I can even tell them, you have to pass, man, because the central government has told. But the shareholders are independent, they can vote for or against. If that was that is why I used to accuse that section always and say, hey, if that is your intention, don't give the option of passing a resolution. You say the company shall change its name. That's all, which is what has happened now. In those days, the section had this major lacuna. In fact, myself and Professor K. Santraman used to have, one of our argument point was this. I used to always say, sir, section 22 is ambiguous, sir. Shall is used, but it is may. No, Shrikant. Don't reduce it to a futility. Intention of legislature. Sir, intention. If the intention of the legislature is to make it mandatory, then why do you have a resolution? Take it off and say, once the central government directs you, the company shall change its name. That's all, matter over. Okay. That is why they built in a clause now which says in case the company does not do it, the central government can do it. Okay. So in a way, now they have made it a little better. Initially, an option is given to you. Then, if you don't do it, they will do it. Rule of beneficial construction is given separately, is it? Beautiful. Thank you. That was my job. Okay. That was my contribution. Yeah. Then you will have to know what is beneficial construction. No. See, when there is there are many enactments which is meant for removing social injustice and bringing about social equality, or bringing about benefit to society. Many laws, Environmental Protection Act, Consumer Protection Act, all sorts of Diversity Act, Biodiversity Act. Then you have gender, what is that? Sexual Harassment Act, Sexual Harassment. These are all clear-cut examples of social justice legislation, where the purpose of a law is to bring about social change or social justice. Then if there is any ambiguity in those laws, they can be interpreted beneficially so as to confer the benefit to the citizen. That is called beneficial construction. Again, there should be an ambiguity. Where there's no ambiguity, you cannot say confer benefit to me. But where there is an ambiguity, when there are two interpretations, one beneficial and to the citizen, other not, then the law can interpret, the judge court can interpret it beneficially. So this is called rule of beneficial construction. Whereas Hayden's rule is where there's a old law, new law is not corrected the defect, it is still continuing the defect, then the judge can ignore the new law and give effect to the remedy. See, they both seem similar. Therefore, there is a confusion between beneficial construction and Hayden's rule. So now, if beneficial construction is separate. So whatever is given in the book, read. Must and shall are similar, sir. There is no big difference between must and shall. So if must and shall are used now, must and shall are one and the same. Rarely will you find the word must being used in law, because must is not a, what shall I say, legal term. But if in any law the word must is used, it has the same meaning as shall. He must go. That means he has to go, no option. But rarely we will use, in a law, if I am drafting, I will not use must. I will use only shall. Okay. In speaking, we use must. But in law, we prefer to use the word shall. Now we move on to the rule of ejusdem generi. The rule of ejusdem generis. Now, this is a very important question. If some of you have feeling this session is becoming very boring, that fellow is telling all sorts of complicated things unnecessarily, acting as if he is Lord Labagras like that, you are right. But what to do? That this topic is like that. Okay. Now, but this topic, now, rule of ejusdem generi, from the exam point of view, very, very important. Frequently tested. So, to an extent, I'm satisfying Karthik by giving one important question in the exam. Rule of ejusdem generi. Try to understand what I'm saying. Even if you don't understand, try to remember. I know, normally I will never encourage mugging up, as people say, but what to do? If you still don't understand, what can I do? I will do my best to explain. Okay. The term ejusdem generis means of the same kind or species. Of the same kind or species. The rule of ejusdem generis means that, I think I even gave an example of this in an earlier lecture. When we came to some other law, we had a series of terms and then we said that whether, I think in, so where I said this will have to take its color from the other words. It cannot be interpreted separately of that. Or can I give it wider term like that? Forget where. Okay. The rule of ejusdem generis means that where specific words are used, and after those specific words, some general words are used, the general words would take their color from the specific words. Take the color means we'll get the meaning. If you I already warned you that there will be Latin terms in this chapter. You have come across only 3 Latin terms as of now: absolutia, absoluta sententia, Okay, absoluta sententia, expositor non-indigent, 1. Then utrus magis. I didn't even teach it. You will never be able to. So I left it. Utrus magis. No need also. Okay. Even if you don't remember the whole thing, if you remember utrus magis, it is enough. Reasonably, it should be reasonably constructed. It should be reasonably construed. Okay. Then generalia specialibus non-derogant. A general rule cannot take away from a specific rule. Then ejusdem generi. That's all. Only 4 we have seen as of now. Ejusdem generi means where, see, there are some specific words and there are some, general words. Now, should I link the specific and general words? See, suppose I'm telling you, in March, I'm planning to visit Prayagraj, Varanasi, Ayodhya, and other places. I'm planning to visit Prayagraj, Varanasi, Ayodhya, and other places. Now, this other places, okay, can it include some hill station? Okay, for example, Jim Corbett or Nainital. This is where the interpretation. Why? Because see the 3 words that I've used. 3 specific words which I used. Prayagraj, Varanasi, Ayodhya. Do they form? See, are they forming some kind of a connection? Okay. Then the last other places should get a meaning, should take the color from the specific words. So we have to see when to apply this rule. The statute should contain an enumeration of specific words. The statute contains an enumeration of specific words. The subject of enumeration constitute a class or category. Now take my example, or I'll give you another example. If you don't like my example, let us leave it. Okay. Let us go towards Gujarat and let us go to some forest. So there I am saying lion, tiger, leopard, and other wild animals. Lion, tiger, leopard, and other wild animals. Now that other wild animals, will it include rhinoceros? Rhinoceros is also a wild animal in Kaziranga. But I am telling lion, tiger, leopard. Do these 3 animals together constitute a class? Yeah, they do. They constitute a class called Felix. Okay, cat family. That means other wild animals, if you apply this rule, it should be read as if belonging. The rule of ejusdem generis means the general principle should be read as if belonging to the specific class. So, lion, tiger, leopard, or cat family. Okay, Felix Leo, Felix tigris, okay, Felix panthera. Now they are all coming from the cat family. If so, then other wild animals include cheetah, jaguar, but not rhinoceros. This is the meaning of this rule. So go back to my example, Prayagraj, Varanasi, Ayodhya. Can it include Nainital? No. Why? Because these 3 places are pilgrimage centers. Basically, pilgrimage centers where we go for pilgrimage. Whereas Nainital, we go for Jali. So it won't come. So I'm just giving example. Like that you can. So there should be, first of all, there should be a list of specific words that should be followed by general words. The subject of that enumeration, that list, see the subject of enumeration, if you don't like, leave it. The list of specific words. Enumeration, you don't like. Simple word, I will give list. The list of specific words. The subject of that list should constitute a class or category. That class or category is not exhausted by the enumeration. See, though I said leopard, cheetah, tiger, the other things also, other cat family items are there. So there are others out there. Similarly, pilgrimage center. Nearby, there may be one Jyotirling's temple also. I don't know. I'm not aware of any Jyotirling in that area. But there could be Jyotirling also. I don't know, I may go. So there may be other pilgrimage centers, I may go. So from Varanasi. So we do not know. I may go to Gaya, which is near, but that is also there. So any other pilgrimage center, I might go. But not Nainital. So that class or category, but think about it. Inside, outside, and everywhere else. Hello? Inside, outside, and everywhere else. See, this is where Hiranyakashipu got into trouble. Hiranyakashipu, suppose he had been smart, he would have said inside, outside, and everywhere else. Whereas he said neither inside nor outside. Thereby he ignored there's one more place where it is neither inside nor outside, on the doorstep, where part of his body is inside, part of his body is outside. He is sitting on the lap. He is neither in the air nor on the ground, neither inside nor outside. He is killed. Okay, sitting on the doorstep, okay, with his feet touching the ground, but body on the lap of the Lord, he is killed by Narasimha. So, see, this is the problem. There he didn't understand law. All he needed to do was, sir, Brahmaji, inside, outside, anywhere else, everywhere else. Then Brahmaji would have been in trouble. Even Bhagavan would have been in trouble. Everywhere else, he has told me, everywhere else. Then only Bhagavan himself realized, everywhere I am there. So I cannot kill him anywhere. Okay. So a point I'm making is that class or category should not be exhausted by the enumeration. That list should not be exhausted. Okay. Of course, in those days I used to say man, woman, others. No, today that is not fair. We have one more category. Okay. Those people who are transgenders, they are highly to be respected by us. And they will come in this category. Okay. So we should not say man, woman, and others. Even as a joke, you should not say. Okay. It is not correct. We should not insult the feelings of our transgender brothers and sisters who are entitled to their way of life and their dress code or whatever they want to do. It is our duty to respect that diversity. So that example I will not give. Okay. We are exhausted. So male and female today have not exhausted gender. There is third gender is there. And we have to respect that third gender, whether we like it or not. Okay. Next. So the general terms follow the enumeration. That means the specific is followed by a general term, like any other or others. Then there is no indication of a different legislative intent. That is, the law should not say we everything else will come here. Like that. Usually, when they use otherwise, there is a different legislative intent. Remember, whenever a section uses the word otherwise, it is wide and you cannot apply the rule of ejusdem generis. Later on, when you come to 386, you will understand 386 now. Yeah. 186, sorry. 186, you will understand that 186 of the Companies Act, you will read it later on, intercorporate loans. There they will say acquisition of shares, acquisition by way of subscription, purchase or otherwise. Acquisition of shares by way of subscription, purchase or otherwise. Now, the minute they use the word otherwise, you can forget ejusdem generis because there is a clear different legislative intent. Because otherwise means we don't have to interpret, we don't have to give you anymore. Any other matter, irrespective, will be included. I cannot dare say, sir, this should be read ejusdem generis, acquisition, subscription, purchase. So this should also be similar to that. Some consideration should go. So the courts have interpreted saying otherwise is wide enough to include gift, etc. Anything. Okay, that etc. is a classic example. The minute you say etc. But generally, as a matter of discipline, when you're writing, don't write etc. If you want, write the full list. Otherwise, use words like other, any other, or thing. Ideally, don't give that opening. Close it. This again was an instruction given by my guru. Srikanth, if you want to say something, say it. Don't say etc. What is that etc.? What is going to come in that etc.? You are unnecessarily creating ambiguity in that. So generally, I will never put etc. If I say something 3 means 3, 4 means 4. Okay. Whereas section 186 says acquisition, whether by way of subscription. Subscription means primary market, when they apply for the share and get it. Purchase means secondary market in the stock market. Otherwise, so otherwise is a white term, which could include any other method of acquiring a share other than acquisition or purchase, right? So now, in fact, in one company secretary institute physical class, long ago, I suppose that was in 1996 or I don't know, 99 or 90, somewhere in that age, that's it, between 95 and 2005, 10 years, that gap. I remember once I was taking the class in the ACS Institute in Chennai, where one boy was sitting there. Okay, he might be now, his children might be in college now. At that time, he was a student, and that boy kept on asking. This at that time, I was teaching the whole section, 372A, similar wording. He said, "Sir, what is the meaning of otherwise, sir? What is the meaning of otherwise?" I said, sir, Mr. X, otherwise means, so I have defined something. And then I said, what is not included also is included. Like that. But in spite of that, he's not understanding what is otherwise, sir, otherwise, sir, otherwise. Then I said, look here, you are wise. I am otherwise. You are wise. I am otherwise. Otherwise means other than wise. He was so happy with that explanation. He said, thank you, sir. Now I understood. But that is exactly the point. Wise is one group. Then other than wise, WASE, wise, is an entire, see, suppose there is a universe. Within that, there is one set that is wise. The remaining part of the universe is otherwise. So the otherwise is a wide term. Whenever the word otherwise is used, clearly there is a different legislative intent, then you cannot apply the rule of existence generally. But if the word otherwise is not used, then you can see whether this is all satisfied and you can apply. Existence generis is a very important topic. Genus means classification. Exhaust means to complete. If that entire genus or if that entire class or category is completed in that enumeration, in that list, then that genus is exhausted. Okay. Genus basically means class or category. Exhaust the whole genus means complete the whole class or category. Okay. Now, sometimes usage or practice is also used, but rarely. Where there's a clear law, you cannot use usage or practice. See, in those days, when the British were there, they were afraid of offending the natives. See, the British were very smart. They enslaved us. No, I think you are all wise. I am always otherwise. I will always remain otherwise. Why? Because only if I agree that I am otherwise, I can learn more. The minute I think I know everything, then how I will learn more? So every day I wake up, I say I'm not wise. Today I have to learn something. So I will be otherwise. Okay. You can be wise or otherwise, your choice. I'm going to be otherwise only. Okay. Now, so when the British were there, no, they used to be very clear. They said, hey, let us not offend these natives, especially religious issues. So whatever these people are practicing, and they also knew that, in India, we have 2 or 3 religions. Of course, Christianity, they bought, Parsis are there, Muslims are there, Hindus are there. Why play games with these people? Let us not offend their religious feelings. Let them do whatever they want. If the minute they say it is a usage or custom, chup, you do it, like that. So they gave a lot of importance to usage or custom, but even they couldn't handle certain usages and practices like sati and all that, child marriage, sati. They prohibited it. They said sati is prohibited. Child marriage, William Benty came. Child marriage was prohibited, like that and all that. But even then, they couldn't make a big inroad because if the entire 1857 revolution had nothing to do with independence. It had much to do with religious feelings. Okay, why did Mangal Pandey refuse to? No, why was there the mutiny? First of all, because they said the grenades that they are using, you have to bite it and to release it, and they are coated with the fat. For the Muslims, they said it is coated with the fat of an animal whose name should not be mentioned, and for us, of course, cow. So immediately, no, I won't do, and then only the mutiny started. Okay, so that taught them a lesson. That never play with these fellows' native feelings. Whatever they say, religious, fold them, fall at their feet, allow them to do it. And that, today also we are saying religion means don't come. Custom and usage, I will not disturb. Okay. So a uniform practice continued is always allowed. But then, sometimes some usages or practices may be prohibited by law. Okay, doesn't mean that a practice which is, just because it is that is why, to a great extent, they did not touch the caste system. To a great extent, they didn't come near the caste system. They didn't understand it and they didn't disturb it also. They said, you guys, you decide what you're doing. Because for a Britisher, a native Indian is no different from an African, guy. They didn't understand them, they didn't understand us. They meet these natives, they say this is a Brahmin, that's I don't understand all these things. They let's not disturb these buggers. Let's get them to work and let's go on with our life. So they decided not to play around with it, and that is why injustice was perpetrated for a long time. Till Dr. B.R. Ambedkar decided to frame the constitution in such a way that the injustice would be corrected. Okay, and what you have today. So custom and usage cannot be, just because it is custom and usage, you cannot perpetrate injustice in the name of custom and usage. Okay. Oh my God. So Divya Kumari is going to get further angry with me. More Latin terms. Okay. Custom is the best interpreter of law, that you understand the English part. Okay. Optima legum inter plus a consecutive. That is, the custom is the best interpreter of the law. This was old British practice. In India, customs and usages are not given so much importance today. If there is a law clearly prohibiting a custom or usage, cannot override it. Okay? Be very, very careful. The law will prevail. Okay? You can't say, sometimes in some villages, they will say, we will not allow the policeman to enter the village and all. That may be your custom, maybe in 1900, 1700 AD. Today, there is a police. And if there is some problem, they will come. You cannot say no. The law of the land applies to every bit and every inch of this country. You cannot say police cannot come and all that. Okay? We are our own law now. Maybe so. You have a panchayat for settling civil disputes, maybe Lok Adalats can be there, panchayat can be there, or elders, a group of elders can be there. But there's only so much you can do. Beyond that, if there is a manifest injustice, there is a law which protects the man, and that law will support him. Okay, mere customer usage cannot prevent. I'm making this point because don't give too much importance to the usage. But in some cases of commercial usage, and I've been giving continuously social examples, but commercial usage. See, in some cases, in some trade, credit will be given for 180 days. It is happening. 180 days credit will be given. That is the usage of that trade. So in that case, you can say, normally, this is the usage. So you can lead evidence also. Witnesses can come and say, yes, in this trade, 180 days credit will be normally given. Like that. So that is usage. So that may be taken into. Contemporaneo expositio. I have only highlighted that. That's enough. That is, the best way to interpret a document is to read it as it would have been understood when made. Okay. Okay. So, a word may have had a meaning, different meaning at the time when the law was made. So, if so, you should try to Muhammad says caste system still exists. I totally agree. I was very surprised to note that in all religions caste is there. I was surprised to note that. All religions have caste system. Very surprisingly. Very surprising. I was sometimes shocked to know. I thought other religions had no caste. Everybody has a caste. Everybody has some sort of hierarchy. And they say we are superior, they are inferior. I think that is the problem. Human beings are like that. We always like to create that I am better, you are less. I think somewhere we should all agree that we are all equal. The minute you all agree, we are all equal, we'll be good brothers and sisters and we can live together. What do you say? So that is the spirit in which youngsters should enter modern India. Not take the baggage of 200 years. Rather, go forward without any baggage. Okay? Go forward with freedom and think, I am a human being. I am a blessed child of God. And I have every right and every ability to come forward in my life. There's no need for me to worry about anything. If this attitude you have, no, everything will fall in place. Okay? After that, nothing matters. Okay? Good. Now, usa ejustem generis, no? Nostider associ is similar. That is, where words are used together, they will take color from each other. Meaning, when 2 or 3 words are coupled together, they'll be understood as if the same. It is like you are known by the friends you keep, they say. So you see me with a group of people all doing bhajan and going to temple, you'll think Srikanth is a good man. Suppose you see me in the bar drinking with a couple of fellows, you say Srikanth is a bad man. Either way, I am good or bad, I don't know. But my company decides whether I am good or bad. That way, a word is known by its associates. Okay. So when 2 or more words are combined, they will give meaning to each other, color to each other. Color means meaning. That's all. Here the word color is used meaning. See how fresh orange juice is not a fruit juice. Yeah. When dealing with the Purchase Tax Act in the old British edition, which used the expression manufactured beverages, including fruit juices and bottled waters and syrups. See, manufactured beverages is the word used. Therein they say including fruit juice, bottled water and syrup. So it was held that the description fruit juice, normally fruit juice includes fresh juice also. But here they are saying manufactured beverages. So the preceding words manufactured beverages will give color to fruit juice. Bottled water and syrup, no problem. Fruit juice. So they very clearly said freshly pressed orange juice. Orange juice unsweetened and freshly pressed is not a manufactured beverage, and it will not come under the definition. See, why are they doing this so much? Because they don't want to bring it to tax. See, what they would have said, manufactured beverages including fruit juices and bottled waters and syrups, 15% tax. Now they are saying you are selling freshly pressed orange juice. We will collect tax from you. So the matter goes to court. Court finally says, look here, though this is a fruit juice, still the word manufactured beverage is used. So freshly pressed and unsweetened orange juice, which is sold across the counter, cannot be a manufactured beverage. So you cannot levy the tax. So you might think, then where can I use it? See, suppose some of you want to become expert in income tax or GST. Your knowledge of interpretation should be good. See, some of you may say, sir, I want to become expert in tax, income tax. I agree. For that, you have to improve your English knowledge. There's no other go. Because you should read the Income Tax Act, understand it, and also interpret it. Interpretation, every word you have to use. So, especially GST. Because in GST, certain items will be clubbed together. No, you can say, sir, Noscidor Associate. You can use the Noscidor Associate. It will get color from its friend. So, the other word says, no, this will also color from it. You have to use. Okay, even though you're not an advocate, if you want to become an expert in indirect tax or in direct tax, into tribunal you can go. As a chartered accountant, you can appear up to tribunal and you can mint money. But for that, you have to learn English. What to do? Okay, so it is your choice. Okay, if you think English is boring, Chaucer and what is that man, Macaulay are bad people, what to do? You tell me. You have to learn English. If you learn, then you will become a better expert in direct tax and indirect tax. Okay, that is why you have to learn law and preferably in good English. Little bit you put your mind to it. First, you remove that negative mindset and say, I don't know English. I don't want to learn English. Start reading books. Start opening your mind. Start reading newspaper every day. Slowly, if you don't know a word, look it up online. Google is there. Aapka haath mein hai. Just look at your Google dictionary. Keep learning words. Suddenly you'll become knowledgeable. See, you are asking me a word and I'm defining it for you. Am I a dictionary? No. Sometime I read the dictionary, understood the meaning of the word, and I'm giving it to you now. So that dictionary is available to you also. Every time you are asking me meaning of a word, Mr. Mohammed, I'm giving it to you. Where did I get it from? Not from some other person. From the dictionary only. Whenever I didn't know a word, I will do research in that word. Like that, I acquired a vocabulary of at least about 150,000 English words. And it didn't happen overnight. And it didn't happen because I expected somebody to teach me. Whenever I read a book, I come across a difficult word, I will look it up in the dictionary. In those days, I used to have huge dictionary, which I will refer you. Every Sunday, at least half an hour, that week, what all words I don't know, I will learn. It used to be. Nowadays, Kar lo duniya mutti mein. It is in your hand. All you need to do is look up dictionary.com. get the meaning. Straight away, Google you go, you will get the meaning. Slowly your knowledge will improve. It won't happen overnight. Okay, there is no magic wand by which your English will improve, your grammar will improve. Over a period of time, it will improve. You have to learn. Whenever you make a mistake, now there is one more. I'm sure all of you know it, and you will say, I know, but none of you will use it. Grammarly, you use it. Put Grammarly in your in your text software, so that whenever you draft a bad ungrammatical sentence, Grammarly will correct it. Grammarly will correct it. And then you will know what is the correct usage. Even after that, if you're going to use a ungrammatical sentence, whose fault is that? Think about it. Whenever I'm corrected by somebody, I will learn and change. I won't waste my time arguing with that gentleman or lady, trying to bullshit and saying, oh, you know this, that, and all. Instead, I'm wrong. I stand corrected. I'm more corrected. I'm going on. This attitude you have, you'll grow faster. The more you argue and say, sir, you are wrong, sir, I know this, sir, I know that, sir, wasting time. Okay. Now, we move on to something called internal aids. Today, you know what I'm going to do with your permission? I'm going to move a little fast without break. Okay? Either that or we can have a small break for 5 minutes. Because we've almost come to the end of this topic. We just have to go for internal aids, then interpretation of deeds and documents. All are interesting only. So, a small break for 5 to 10 minutes. Sir, small break, sir. G, small break. welcome back from your break. Just thought I'll have a small break and I'll see. See, Mr. Srinivasan, you have been asking me for this a lot. I am sorry, I am not prepared for it today. But to my knowledge, all the amendments which are now being uploaded in the portal were covered by me in my lecture. So separately, I don't think we have to cover the amendments. It's there. It's not much, and it is there in my notes. Wherever there's an amendment, I've included that amendment. So I don't think it's something important. There's nothing very important in those amendments. So don't worry about it. And it is there. Or else you just read it in the context of, just read it and then go to my notes and see whether it is there. If still, I don't think you'll have any problem in understanding. So don't mistake me. But there's no need. There's no need for you to get worried about it. You just go and see it. Just read the amendment, read the notes, the appropriate portion. You'll find that it is covered there and you'll know what it is. When it came, I would have definitely covered it. At the time of that topic, I would have covered. Okay. There is no need to again go through it. So you should develop that type of a thing. Just go and see what it is. It will be there. Okay, now we are going for internal and external aids. Aid means help. So where the words of a statute are having some double meaning or ambiguity, then I have to interpret. Then where will I get the support for that interpretation? For that, I can look at various places of the enactment law. One of the places is the long title, okay, meaning the full title. Another, you will find that long title is there. When you open a barrack, you'll find that there is a long title, an act for the purpose of bringing together law, something like that. There is a long title. Short title is the Companies Act 2013. Okay. Some long title can see short title, how you can use. There are only 3 words, 4 words. But long title you can use because it almost is like a preamble. Preamble gives the scope and object and purpose of the act. Many laws have a preamble. When there is a preamble, can I use the preamble? There is one general rule which says anything which was there, which was part of the law at the time of passing in Parliament is a valid aid. But it was not part at the time when it was made a law in Parliament, then it is not an aid. So long title is there, short. Preamble, yes, because it is very much there at the time of aid. But when I can use the preamble? Only when there is an ambiguity in the main law. When the section has an ambiguity, then I can use the preamble, either for resolving the ambiguity or for restricting the scope. See, when the law becomes too general, I can go to and it's vague, I can go and say, look here, the preamble itself says it's only applicable in these cases. Why are you extending it to anywhere and everywhere? This is the point. Heading and title of a chapter. See, if some of the older enactments, you will find, and even in Companies Act, you find chapter headings are there. Am I correct? You have prospectus and allotment of securities, chapter heading. Okay. So this heading can also be used. Title of the chapter can be used. But sometimes in some enactments, you'll find sections will have summaries and section will have a heading. Now, some groups of section, they will try to bring together under one heading. In some laws, you'll find it. Companies Act, old law had, new law doesn't have. When this happens now, you have to be careful because when the law was passed in Parliament, these summaries were not there. Sometimes it is also called marginal notes. Marginal notes, 100% it is not a aid. Why? Because, see, when the act was passed in Parliament, heading was there, title could have, chapter titles could have been, heading could have been there. But these marginal notes were not there. Later on, some bureaucrat or somebody summarized while printing the law in notification. So sometimes it's not used. It's okay. But exceptional cases, you can use, some courts have said. Okay. So I've given, that's why one example has been given where Patanjali Shastri has declared marginal notes in an Indian statute as in an act of parliament cannot be referred to for the purpose of construing the statute. Once in a while, but rarely. So that is why the general rule is that marginal notes, because marginal notes are put in place after the law was passed in parliament. See, the law is passed in parliament, both the houses of parliament, goes to the president. Then it has to be notified now. At the time of notification, somebody in the central government will try to do all these marginal notes and all. Not part of enactment, not to be used for interpretation. Which is why, if you want to know what is the original content of the law, you have to see the notification. And as it came in parliament, from parliament, it will be published. Definitional sections, interpretation, you know that. Okay. A definition is always useful, but that definition should be applicable to that section. Okay, if in one section a word is specifically defined for that section, you cannot take that definition and apply it elsewhere. Okay. So definitions could use the word mean. Mean means straight away. It is restrictive, exhaustive. Relative means. That means only these people are relatives, not the doubt. But when the minute you say include, then it is extensive, not exhaustive. It is an inclusive definition. Securities is an inclusive definition. You can go and check whichever definition we studied. If they use the word include, that means they will say, finally, they'll say any other security as may be notified by the central government. It will become inclusive. Okay. Income is an inclusive definition in the Income Tax Act. Sometimes they will say means and includes. That also is inclusive only. Merely because it says means and includes, it doesn't become exhaustive. Means and include means they are giving it a definition, but not restricting it. They're saying this is what we think, but it includes. Current account transaction, not defined. But they're saying it includes these items and giving 4 examples. Okay. If the word is defined to apply and to include, it will be extensive. Okay. A definition section may also be worded as deemed to include. Even though it is not that meaning, it will be deemed to be included. Okay. In some enactments, in fact, one of the enactments which has a lot of illustrations has been removed from a syllabus. The Negotiable Instrument Act, which is having so many illustrations, has been removed from a syllabus and taken to, I think, foundation or whatever. Enjoy. Okay. Now, so I suppose you are aware from foundation or whatever. So they used to have a lot of illustrations. Most Macaulay legislations will have a lot of illustrations. Sale of Goods Act, Indian Contract Act, Indian Evidence Act, a lot of illustrations will be there. But illustrations are definitely part of the statute, but you cannot directly go to the illustration and interpret. Where the words are clear and unambiguous, where the main section is clear, you cannot contrast it with the illustration and say, illustration is like this, therefore this is the meaning. No. Illustration cannot modify the language of the section. Illustration is only meant to give an example. See, for explaining the law, I'm giving some examples. That example cannot control the law. Okay. Long title and short title are there only for identifying the long. Rarely can use them for interpretation because they are so short. Rarely. But they are saying it is a part of an enactment and therefore it is there. The Companies Act 2013 is the short title. An act for consolidating the law relating to companies, etc., etc. There is a long title. Check out. You will find the long and short titles. Okay. Illustrations. Proviso. We have seen many examples where they will say, in my notes, I would have removed provided that. But in the original section, you will find provided that. In your Board of Studies material also, you will find provided that. I would have removed provided that. Because they are creating an exception. I would have stated it as an exception. Generally, provisos are exceptions to the rule. Wherever there is a main section and they want to say this won't apply, that won't apply, then they give it as a proviso. So they will say, all of you have to appear for the exam on so and so time, or all of you have to write the new syllabus, provided that a student has already written this paper, need not, right? Provided that. So these are all exceptions. So generally, they'll make it applicable to everybody and then say, hey, these situations, provided that you are applicable, this is applicable to you, then you are out. So proviso will accept something, and proviso cannot control the main section. You cannot use the proviso to interpret the main section. Okay. Usually exceptions are given in separate clauses. For example, section 185 and 186 do not apply to certain situations. They'll give a separate subsection. There is an exception. They will first describe the entire concept and then say, this section does not apply to the following situations. That is called exception. Whereas proviso is used in the subsection itself. In that subsection itself, they'll give a thing and say, provided that, where this is there, then it's not. So they are carving out an exception and taking it. Saving clause. Okay. When a whole law is repealed by a new law, the new law will say the old law is repealed, but section so and so, section so and so. For example, any appeals pending under the old law can still be proceeded under the old law. So those sections are relating to appeal are applicable. Any offense committed under the old law can be punished under the old penalty provisions. So the old penalty provisions will apply only with respect to offenses committed in that law, under that law at that time. Okay. So these are called saving clauses. So in an offense committed after the day of the new law, you cannot use that section. You have to come for the new section. But if that offense was committed under the old law, at that time when the law was effective, then the old penal provision will still continue to punish. So like that, they can save certain sections from destruction or any right or remedy. For example, right of appeal will continue. Any appeal pending will continue under the old law, like that. Many sections have explanations where they feel that they have given some complicated rule or they have given you certain words which could be ambiguous or capable of two meanings. Then they might give a clear-cut definition or clear-cut clarification and say, for the purpose of this section, this is what it means. The object of an explanation is to explain the meaning or the intention of the act itself. If there is any obscurity or vagueness, that's why sometimes they'll say, for the removal of doubts, it is clarified that. And it can also provide an additional support. Explanations are there, but then you cannot give a right in the main body of the section and take it away in the exception. If you want to do that, you create a provision. You cannot say it is all applicable. Here, you don't know it is not applicable. No. Okay. You know very well about schedules. How many schedules does the Companies Act have? How many schedules does the Companies Act have? The Companies Act has how many schedules? It's like a quiz contest. Any idea? How many schedules? Correct. Divya Kumari gives Man Lodari gives correct. Mohammed Ji, when there is an old law, that law will apply only for the old period. Once that law has been superseded by the new law, from that day onwards, the new law will apply. So you cannot be required to comply with both the laws. But suppose you have committed an offense under the old law at that time, that offense will be punished under the old law. Are you able to understand, Ji? Yeah, many of you are giving the correct answer. 7 schedules are there. 7 is correct, not 6, 7. 7th schedule talks about what is infrastructure and things. I'm sorry, 7th schedule is, I think, CSR. What is CSR? Okay, so there are 7 schedules. So these schedules are very much a part of the enactment, especially Schedule 3 has so much notes. All that is part of the enactment. which is why you have to be very careful about it. However, where there's a clear provision in the law, the schedule cannot control or prevail. Okay. But a word used in the schedule can be used for interpretation of a section. The word book date it used to be defined in the old Schedule 6. I think it's now not defined, but or maybe it's still defined in this Schedule 3. So if such a definition, if the word book date is used in the law and not defined, and this is defined or explained in the schedule, I can always say, hey, the schedule says book dates meaning this. That is what the meaning, that's the same meaning you have to give there. Okay. So what we have seen are all called internal aids. Now we move on to external aids. External aids. Like historical setting. Historical setting. What was the background when it was enacted? Consolidating statutes and previous law, like Hayden's rule. When there is an old law, what was the old law all about? See, if you look at FEMA and FERA is the previous law. So you may want to look at what was there in FERA. Similarly, the Income Tax Act, successively amended. Many sections have been successively amended. Still, once a section is amended, the news, especially in Income Tax Act, you have to be very, very careful. Certain amendments come into force for certain assessment years onwards. So from only that year, that new section will apply. Old law, the old section only will apply. Like that. So prospective, the law will be made prospective or retrospective. Most taxing statutes, unless otherwise stated, are prospective. They will be applicable only from the time they are effective and forward. They cannot go backward, with rare exceptions. Which have been retrospective. Usage, we have already seen. Sometimes you can use, but in my humble view, too much usage also, you cannot take too much. See, when the law is very clear, you cannot use usage and all that. You see, you have to be very, very careful. Earlier and later acts and analogous acts. See, for example, if you go strictly by Manu, female descendants are not entitled. Okay, so if you go by all that, you can do. But today, Succession Act is very clear. Male or female entitled to father's property, mother's property, both. So both daughter and son are equally entitled to the both legal heirs. You cannot say daughter is not entitled, married daughter not entitled. No, everybody is entitled. Okay, unless there's a will. The gentleman or lady dies intestate, that is without any will, then both daughters and sons are equal. Everybody gets, okay. That is the point. So the old customs and usages cannot be applied now. Okay. The law is now amended. Okay. Earlier and later acts and analogous acts. See, analogous acts means similar. If you don't like the word analogous, very long, sir, then you can use the word similar. I don't like similar also, sir. Give me simple word. Like. This law is like that law. Same law. If you want me to go simpler than this, sorry, I cannot go. Okay. Right. Seriously. Today is my last class. Give me the benefit of telling like this. Try to improve your English. Come to a level where you will understand all this rather than keep on saying, I don't understand. How long you will be ignorant? How long have you decided to remain ignorant? You decide. You decide, I will be ignorant for the next 10 years. I will not learn English like that. Don't do that. Start learning. Please start today. Okay. Dictionary definitions. Yes. Where the law is not defining the word, where the word is not defined in similar or analogous act, where there is no other support even in General Classes Act, then I can go to dictionary. There are many good dictionaries. Oxford English Dictionary is one. Cambridge, the New Webster's Dictionary. Seriously. For example, once upon a time, you're not going to believe this. I have a library in my second floor. As of now, I have about 23,700, about nearing 24,000 books. Nearing 24,000 books collected over from when I was 12 years old. From that age, books collected are all stored in my second floor. Books and cupboards are there. Now, in that, sometimes, people come and ask me, Mr. Srikanth, have you read all these books? I said, obviously, I have not read because out of that, easily about 2,000 to 3,000 are dictionaries and encyclopedias and reference volumes. So obviously, I have not read all. I'm not so mad, yeah, to read a full dictionary and all that. But then, as I told you, there are easily about 20 dictionaries that I used to refer. Whenever a word is defined, I'll go for Webster, then Oxford, then Cambridge. Okay. Today, example of Analogous Act, Companies Act, Securities Contract Regulation Act, SEBI Act. These are all analogous, similar, like, same. Okay. So, what I'm saying now, the dictionary, the best dictionaries are there, but then you can refer to any dictionary. Okay? Today, you don't see my entire library, much of it has lost its meaning because completely it's in my, it is here in my hand. My encyclopedia is here, my dictionary is here, everything is here. Okay? So, why should I? All I need to do is either, today, even the app is a free app only. But if you want to go, you can subscribe to higher level like that. Okay, good. So don't say last class means what to do. In fact, I'm reminded of our great railway, the past ex-railway minister Lalu Prasad Yadav ji, who said, somebody complained to him and said, sir, because there is a last compartment in the train, I am unable to board, I have to go to the last compartment. Immediately, Lalu ji told his officers and all, please ensure that in future, no train will have last compartment. So like that, there should be a last class. How can there be a session without a last class? Anyway, foreign decisions are not binding on Indian courts, but can be used by Indian courts for understanding the situation, and maybe they have some kind of a persuasive power. Okay, but you cannot quote it as sort of a right to apply. Whereas if it is see, for example, I practice in Chennai, which means Madras High Court is my jurisdictional High Court. So when I appear before CIT appeals and all, I can quote Madras High Court, I'll have more value in Tamil Nadu. Though for a central enactment, that is bullshit because, see, if there is no Madras High Court decision and there is a Gujarat High Court decision, being a central enactment, there is no way Gujarat High Court decision cannot be taken. It should be taken. If there is a Madras High Court decision and there is a Gujarat High Court decision, maybe the Chennai tribunal can prefer the Madras High Court because jurisdictional High Court. There is a conflict between the two. Okay, like that. Finally, we come to interpretation of deeds and documents. The golden rule is to ascertain the intention of the parties to the instrument after considering all the words in the document, in the ordinary and natural sense. Okay. You can't give different meanings to the same word in the same document. Of course, context sometimes may change. Okay. Sometimes there could be vagueness in the document, in which case you can use interpretation. Okay. It may happen that the same word understood in one sense will give effect to all the clauses in the deed, while taken in another sense, it might render one of more of the, in which case you should prefer the word which would be giving uniformly the same meaning everywhere and making it. In case there is a conflict between two or more clauses or parts of the same document, an effort must be made to resolve the conflict by interpreting the clauses so that all the clauses are given effect. An attempt should always be made to read the two parts of the document harmoniously. But it is not possible, then earlier part will override the latter one. This is the rule. So something stated earlier will be superior to something stated later. So if there is a conflict between the two, you should say earlier will be better than later. Sometimes in badly drafted deeds, you will find the same right is conferred in two different clauses in different ways. So then which one should be taken? I would say whatever was stated first is the right conferred. Take that and not the second one. You can say. So at this point in time, I have come to an end of my lecture. There is no further thing in interpretation to be taught. Weightage wise, this is not a very big topic. Maximum 6 marks. for surely you'll get one question out of it. So think about it and really enjoyed uh, interacting with all of you. Of course, sometimes I could be a very, very opinionated man. And that's how it is. But whatever it is, I enjoyed interacting with you all. And I hope I have been of some benefit to you. And I look forward to meeting all of you in future when I come to that part of the world or that part of the country. Definitely, I would like to. If I mean, in a professional meeting or somewhere where I'm there, if you see me, because you know me, I don't know you, I don't know your face. So if you know me, you can come. My full name is Srikant. Yes. My father's name is Sridharan. I'm called Srikant. Yes, or Sridharan Srikant. Okay. Yeah. I think on LinkedIn and Facebook, I'm known as Sridharan Srikant. SREEDHARAN. Sridharan, my father, also a chartered accountant, very senior, 82-year-old chartered accountant, and Srikant, me. Yes, Srikant. Or else simply in Tamil Nadu, we have only initial. So, yes, Srikant. You are welcome and you can take it. Thank you for all that. If you have any doubts, kindly communicate them to the Board of Studies through the query site or whatever, and I will definitely take them. I totally agree that FEMA notes are to be uploaded and interpretation. Both will be uploaded. Okay. We will. Thank you very much. Nice of you. And looking forward to meeting you and wishing you all the very best in the exam. And looking forward to hearing good news about you in the near future. Okay. I want to know that you cleared the exam. I will pray to God that you should clear the exam in the near future. Thank you very much. Bye. Sir, Manish ji, yeah, class over, sir, today, earlier. Thank you. Thank you, Mr. Raj.